Hey guys, that's for everyone. We're redoing the laws video once again. A few things have changed. We want to update that. I did do an update, but Isaac wasn't around. We found him in a dungeon somewhere, and they allowed him to do this one short video for us. So we're gonna redo the laws video. If you're watching this video, you probably got it. Most likely, you got it via a link in the email for the class. These videos are primarily done for our classes, our concealed carry classes. These videos, from experience, they've helped us a lot minimize the amount of time that we talk about legal stuff in classrooms. That doesn't mean we don't want you to ask questions in classroom, but it does help us kind of minimize the amount of time we talk about them in classrooms. So also, it's a reference point for you from here on out. If you ever want to hear the laws again, you want to hear my sexy voice. Here we are with the video again. Watch the video, get to the laws, most likely answer whatever question you have. So hopefully it's a helpful tool for you guys. I think this one I'm going to publish, make it public for everyone. That way it's just available there for everyone. So I'm going to try not to use bad words. I'm going to see how long I can go without using bad words, so we don't get demonetized
Just
or get.
remember, it's more work for you
Yeah,
afterwards.
yeah, yeah, for sure. Just because everything's getting crazy and community standards and stuff like that. So I'm going to try my best not to use bad words, but no promises on that. If you do show up to my class, there's going to be a lot of bad words. A lot of bad words. Anyways, Isaac's here. Anything you want to say before we get this show on the road?
Yeah, just that we have been using these video format for the laws for a couple of years now since COVID. And even though you might resent us for making you watch a video before or after the class, I can tell you that it makes the class go a lot smoother than trying to do all this in the class. And you're strongly encouraged to watch this video multiple times. We've been doing this for a very long time, and I can tell you from experience that it is helpful to review the laws on a somewhat regular basis. There's no way you're going to memorize this all in one try.
Yeah, I mean that's primarily the thing is one, it makes the class go by a lot faster because again we don't talk about the legal stuff as much in classroom. We cover the nuances if you have clarification stuff or what have you, but yeah, the stuff is here. It's in video. You can always reference it. The website that you can also go to, I'm going to put it up on the screen right now, is LexisNexis. That's the website. The exact URL is www.lexisnexis.com/hot topic/Colorado. I know it's silly in 2023 to have that triple W, but that is indeed the actual URL that you must go to get the laws. That is the official site for the state of Colorado. So if you go to the Colorado legislature, as of this video, anyways, LexisNexis is the official website for the laws here in the state of Colorado. So anyways, we bring it up. I'm going to bring it up. We're going to kind of read it, and we'll probably hit the high notes of where I don't think we want to read line by line every single thing that it says. But once you go to that website, it's going to come up with this. It says you have to consent to giving up all your data, all your banking information. Your firstborn, I think, is part of this agreement. All of that scary stuff. Um, the the parts that you want to go to for this is going to be down to Title 18, which is the criminal code. Before we go to that, I do want to make a point that under local government or government local, Title 29, under miscellaneous, if you go down to miscellaneous, and if you go to 11.7, regulations of firearms, I know some of you guys are going to be intrigued by the one below it. I was. But 11.7 is where you would read local regulation stuff. One of the interesting ones is like this one right here, where it's prohibited by Colorado state law. It is against the law to register firearms, but stuff that has absolutely nothing to do with concealed handgun permits has nothing to do with you necessarily obtaining a permit, but it does have to do with local laws in general for firearms. So again, that's going to be in Title 29 under miscellaneous 11.7, and that's regulations of a firearms at a local level, what they're allowed to do, what they're not allowed to do. That's important as of 2021 as well. We lost preemption in 2021, so it talks a little bit about that. But the primary one is going to be Title 18, and then we go down to 12, Article 12, offenses relating to firearms and weapons. The one that we're going to be spending a lot of time on is part 2, because that's what you're in class for, is permits to carry concealed handguns. So that's going to be 1812 part 2. But as you can see, large capacity ammunitions, ammunition magazines, dealers, background checks, firearms and weapons in general, all that stuff is stuff that we highly, highly recommend. One of the ones that Isaac wanted to talk about was the secure firearm storage that passed. This one passed in 2021?
Correct. Yeah.
Go for it.
The secure firearm storage is intended to prevent unlawful access of a firearm from an unauthorized person. You're encouraged to read through this carefully. Essentially, the idea here is that you can live with people that are not supposed to have guns, and you can own firearms, but you cannot allow them to have unauthorized access to the gun. So that would include people like convicted felons or otherwise prohibited people, people on probation, people under court order to not handle firearms. If you live with people like that or interact with people like that, you are required by law to not provide them with access to your guns. Access to your guns would be an unsecured firearm. Secured firearm includes putting the gun in a safe, otherwise locking the firing mechanism with a cable lock or a gun lock, having the firearm under your immediate control, like carrying the gun in a holster, things like that. So, you can live with the crackhead if you want to, and you can own firearms, but you cannot let them have access to the firearms. This also includes minors, people under age 18. Now, the way the law is written, it doesn't exclusively prohibit you from giving access to a minor, giving a minor access to a firearm. It's a little tricky in the wording there. If you want to play it safe, keep your guns locked up. If you want to exercise your rights as a human being, read the law closely and make sure that you understand what is and what is not allowed under that. Anything you want to add to that?
No. I was kind of iffy we should even talk about it, but a lot of you guys come to the class and don't even really end up applying for your concealed handgun permit. A large portion of the population that show up to our classes don't end up getting their concealed handgun permit, but obviously you carried a lot in your home. So I encourage you guys to read a lot of this stuff. Some of the stuff that you guys may be interested in that has nothing to do with your permit per se, but it has a lot to do with you traveling with firearms. So 1812-105 is one of the sections that you might be interested in. The other one is 1812-105.6, limitations on local ordinances regarding firearms in private vehicles. Basically, cities, local governments in general are not allowed to prohibit you from carrying in your vehicle without a permit, that type of stuff. So it's a lot of stuff that highly encourage you guys to read. Again, has nothing to do with your guys' permit. So we're not going to dabble in that too much unless we read a law and we need to kind of reemphasize or reinforce what we were talking about, that type of stuff. But anyways, again, lexusnexus.com. I'm going to put it back down, lexusnexus.com/hot topic/Colorado. And again, the way it is on the screen is the way you should enter it. I'll put a link in the video, probably the best way to do it if I'm not lazy. I might get lazy on you guys, so I may not do it. But anyways, if we go to part 2, kind of go in order. The legislative declaration, basically, why was this law created? In part, this law was created because there was a lot of inconsistencies from jurisdiction to jurisdiction. So this was created to essentially create a uniform law on how to on your requirements and the sheriff's requirements and all of that stuff at a state level. So it's one uniform law across the state. For me, the big one here is subsection 3. Again, please read all of this stuff. But subsection 3 is in accordance with the findings and conclusions specified in subsection 1 and 2 of the section. The General Assembly hereby instructs each sheriff to implement and administer the provisions of this Part 2. The General Assembly does not delegate to the sheriffs the authority to regulate or restrict the issuance of permits provided for in this Part 2 beyond the provisions of this Part 2. An action or rule that encumbers the permit process by placing burdens on the applicants beyond those sworn statements and specified documents detailed in this Part 2, or that creates restrictions beyond those specified in this Part 2, is in conflict with the intent of this Part 2 and it is prohibited. So, two things for me. Lawyers suck at punctuation because run-on sentences there like it was forever. I like commas. Ask Isaac. I probably like him a little too much. That's a mouthful. Big thing here is basically just what it sounds like. The sheriffs are the ones that administer the process, unless you live in Denver or Broomfield, in which case it's the city, the police department. We'll read that a little bit later. But the other one is sheriffs don't really get to decide what the requirements are. They don't decide what the requirements are, what you need to do. State law says, again, we'll read this in a little bit. I know I'm jumping a little ahead, but just as an example, you're not required to shoot to get your permit in the state of Colorado. And some sheriffs in the past and currently right now have required that. And that's a big no-no. Cannot do that. In fact, we sued Larimer County during COVID because they were requiring more than what was legally required. We sued them, I would say successfully, in the sense that they reversed their decision and they went back to following the law. Unfortunately, we didn't get a judgment on that, but we did get them to reverse what they were doing and change what they were doing, because what they were doing was illegal, requiring more than what this Part 2 had already required. So that's the big one for me.
Yeah, just to add to that, the reason why we're spending so much time on this is because we've been doing this a long time. We've seen a number of students over the years get into conflicts with the sheriff's department about requirements, and hopefully the easiest route out of that is just guns for everyone, or the student educating the sheriff on this particular statute and what they can and cannot do. We have had to sue. We have threatened to sue. We plan to sue in the future. But really, you are the first line of defense on this, and you need to advocate for yourself if the sheriff is not following the law. This is important when it comes to keeping the state and government and sheriff's department in check and following what the law says. And we do expect you guys to stand up for yourselves, and we will support you in that as well. But we're covering this because it's been an issue.
Yeah, absolutely. Let's move on to 1812-202. And if you're on the website, all you have to do is click on the next, and it's easy for you to kind of flip through it. We also have this on our website. All of this information is a little bit more, I guess, quote unquote, organized on our website, concealedcarryforfree.com, under resources and obviously Colorado gun laws. We do have all of this information. Basically, all I did was download this stuff and re-upload it. We categorize it a little bit more. So you can also go to our website, concealedcarryforfree.com, again, under resources and then Colorado gun laws, and you can find it there. By the way, you can also find your applications for your sheriff's office, for most of them anyways. Definitions, the ones that I like to kind of highlight here in terms of definition is what a certified instructor is. There's a few of them. If you read ABCD, the one that most instructors are going to qualify under in the state of Colorado is a national nonprofit organization that certifies firearms instructors, operates national firearms competitions, and provides training, including courses in personal protection, small arms safety use, and marksmanship. So I myself and Isaac are both certified through the NRA. but more importantly, through Guns for Everyone National. Guns for Everyone National is one of the organizations that we want to push out a lot more. It's kind of an alternative to the NRA in terms of on the training side of it, but both of those are national nonprofit organizations that certifies farms instructors and does the rest of what it says. And again, that's 1812-202, 2D. Most instructors would fall under that for being able to sign off on documents and stuff like that. One other one that I'd like to point out is a federal military agency. Not anybody who's enlisted is a certified instructor. You would have to be qualified to be an instructor within that branch of the military. That's important to understand. The Peace Officer Standards and Training Board. That's another one where just because you're a cop doesn't mean you can do the classes. You would have to be a certified instructor, a firearms instructor for the post board, basically. So it's a little bit more complicated than that. But yeah, that's what would qualify you as a certified instructor. That's why Isaac and I are able to sign off on your certificates. And then the other one is handgun training class. All right, I confused the 4 and the 5. I thought I lost it. 5A, a training handgun training class. We fall under subsection 2 and subsection 3. Subsection 2 being a firearm safety course offered by a law enforcement agency, an institution of higher education, and the one we are is a public or private institution, organization, or firearms training school that is open to the general public and is taught by a certified instructor. Or again, we also fall under this one, a firearm safety course or class that is offered and taught by a certified instructor. Now, the law does say that you cannot, it says so right here, notwithstanding paragraph A of the subsection 5, handgun training class does not include any firearm safety course that allows a person to complete the entire course via the internet or an electronic device, or in any other location other than the physical location where the instructor offers the course. That one's kind of self-explanatory. But there is no training requirement. Like there's no shooting requirement. If you read here, it doesn't say it has to be 8 hours long, 6 hours long. So there's no time requirements. There's no shooting requirement. All it is a firearm safety course. That's about as specific as it gets for that.
Yeah, we're not required to even go over these laws in the class, and that's important to point out because it puts the responsibility on you, the student, to know these laws. We're offering you this information. We're making it relatively easy for you to get it from us. As boring as Edgar might be on this, it is easy enough for you to sit and listen to this video a few times and get this information, but we're not even required to present it to you.
Yeah. Training certificate means a certificate, affidavit, or other document issued by an instructor, school, club, organization that conducts a handgun training class that evidences an applicant's successful completion of the class requirement. That is it. We don't have to add any special stuff to the certificate. It doesn't actually even have to be a certificate. If you notice, it says affidavit or other documents. We choose to do the certificate stuff. But yeah, anyways, these were the things that I wanted to talk about in terms of what the definitions were. Anything for you, Noon?
No, that covers the important stuff. There is some stuff in here about alcohol abuse, and if you do have any kind of alcohol restrictions that are going to affect your ability to get a permit, it would serve you to come in here and read these. They're not that complicated. But this is where you're going to find some of those definitions.
Correct. Yeah, absolutely. Let's move on to 1812-203, the criteria to obtain your permit. Criteria for obtaining a permit. Read this. Basically, it's your standard stuff. You're a legal resident of the state of Colorado, 21 years of age, is not ineligible to possess a firearm, 1812-108, blah, blah, blah. The training requirement for you guys, this is where a lot of people get hung up. For me, anyways, it's mostly Jefferson County people who will email me or call me or send me a message through the social medias and say, hey, Jefferson County requires you to go shoot. And when I ask them, who told you that? Where do you say it? Well, it says demonstrates competence with the handgun by submitting. And then they just stop there. I don't know what it is in Jefferson County. Maybe it's the water, or the Coors Light is bleeding into your stream, your sink. I don't know what it is. Um, but you have to continue reading. So demonstrates competence with the handgun by submitting one of the following. The one that you fall under when you show up to the class is 6, subsection 6, a training certificate from a handgun training class. So remember, we just read what the definition of a training certificate was, and we just read what the definition was of a handgun training class. Obtained within the 10 years preceding submittal of the application, the applicant shall submit the original training certificate or photocopy thereof that includes the original signature of the class instructor to the extent permitted by Section 1812-2025. In obtaining a training certificate from a handgun training class, the applicant shall have discretion in selecting which handgun training class to complete. So that's how you would do it. So when it says demonstrates competence with the handgun, doesn't mean you have to go shoot or anything like that. It just says you have to do one of the other ones. Military people, you are covered under 4, proof of honorable discharge from a branch of the United States Armed Forces that reflects pistol qualification obtained within the 10 years preceding submittal of the application. Now, if you don't have that, your DD-214 is valid for 3 years, and I think that's the one before that. Yeah, 3, proof of honorable discharge from a branch of the military, 3 years preceding submittal. That's if you don't have pistol qualification in your separation paper. So 10 if you do, 10 if you do not. But you could also be a competitive shooter. Evidence of experience with a firearm through participation in organized shooting competitions or current military service. Oh, that's the other one, active duty.
Yeah, on the competition shooting, it says evidence of participation, a score sheet, something like that, a roster. I've had a couple students come and tell me that the sheriff did not accept their demonstration with something like that. It's not specific of the evidence type, and I think that again, it's on you guys. I mean, we'll back you up and we'll help, but if you present evidence to the sheriff's department that meets the criteria, any of the criteria that you see here, and they won't accept it, again, advocate for yourself. It's a lot faster for you if you can convince them to read the law and accept it than it is for you to come back and ask us for help, and then we help you, and then it takes weeks or longer. Not that we're not willing. We're more than willing to go have an argument with the sheriff, but it's faster for you, and I think it's good exercise for you to stand up for your rights and read this stuff carefully. And if it's presented accurately, then stand up for that.
Yeah. So 2 right here is basically the sheriff has a reasonable belief that documented previous behavior by the applicant makes it likely the applicant would present danger to self or others. So they have a small discretion to deny you based off of your criminal history. So it doesn't mean they get to decide what the criteria is, because again, it's based off of documented previous behavior. So again, your criminal history is what they're going to go off of. It doesn't give them the ability to decide what the criteria is. It's all based off of your previous behavior. Anything else here?
No. Well, so in section 3B, if the sheriff's department has a reasonable belief that a permittee no longer meets the criteria specified in the above sections, the sheriff shall suspend the permit until such time as the matter is resolved. So you can expect that if, for instance, you've got a extreme risk protection order filed against you, somebody may be saying to the court that you're abusive or things like that, expect your permit to be mixed up in that, because the sheriff is required to suspend the permit if there is a reasonable belief.
Yeah. 1812 204. The big one for me here is subsection 3, and that's a person who may lawfully possess a handgun may carry a handgun under the following circumstances without obtaining a permit, and the handgun shall not be considered concealed. So even if you are carrying it concealed, it shall not be considered concealed. The handgun is in the possession of a person who's in a private automobile, some other private means of conveyance, and who carries a handgun for legal use, including self-defense, or the handgun is in the possession of a person who's legally engaged in hunting activities within the state. Uh, Private automobile, private means of conveyance. You can carry your handgun. Again, this is pretty specific when it says handgun. Your handgun without a permit, and the handgun shall not be considered concealed. Rifles, shotguns get dealt with differently. Some of you guys are saying there, well, what about pistols? If it meets the criteria for a handgun in the state of Colorado, then it's a handgun. Look that up in part 1. You'll be able to find that up in CRS 1812 part 1. Again, go to lexisnexis.com/hot topic/Colorado. Go to 18, go to 12, go to part 1, and you'll see what the definition of a handgun is there. The other one that a lot of people are suspicious about is the handgun is in the possession of a person who's legally engaged in hunting activities within the state. Yes, you can have a handgun fully loaded, ready to pew pew, all while you're trying to kill Bambi. The law allows you to do that. Now you can't hunt with the handgun because that is it's for self-defense. It's not for hunting purposes. So that's the difference. You're not using the handgun for hunting purposes. But in case you need to take out a grizzly or there it goes. What time is it? How far in? 27
I
minutes
heard
in.
duck. We're talking about hunting. You said something about ducks.
Ducking. Yeah, ducking.
Yeah.
Yeah, ducking.
Yeah.
I did say ducking. It was not. Whatever it might be, you need to defend yourself. That's what the handgun's for. So
yeah. One thing I want to add to this, because this question comes up a lot in the classes, is you nerds who want to carry around a AR pistol or an AK pistol in your vehicle. And if you read the Colorado law around the definition of a handgun, the high points are that it's a firearm barrel of less than 12 inches and no shoulder stock. There is no definition of shoulder stock that is in conflict with federal law, but the issues going on in the last couple of years around shoulder stocks and braces, according to ATF rule changes, create enough confusion.
I don't think it says anything about stocks, does it?
It says no shoulder stock.
Let me see. That's cool.
Yeah.
So this is going to be 1812 101 definitions, machine gun, personal show. Handgun means a pistol, revolver, or other firearms of any description, loaded or unloaded, from which any shot, bullet, or other missile can be discharged. The length of the barrel of which, not including any revolving detached magazine, does not exceed 12 inches. So it says nothing about the stock.
Okay. All right. So the issue, the real issue here for you, if you're carrying around one of these AR pistols in your vehicle, is the law enforcement's inability to understand the difference, and getting yourself into a problem that maybe you didn't need to have. You can decide what you want to do around this, but the issues that have happened in the last couple of years around federal definitions of rifles, shotguns, etc., pistols, you should understand that it is a little bit more risky to carry around your 10.5-inch AR pistol in your trunk if you want to carry it loaded, etc. It does meet the definition of state law, but that doesn't mean you're not going to have a problem.
Correct. Yeah, that's the big thing right there, right? Is under Colorado state law, your braced AR pistol is good, but it doesn't mean that under federal law it's good, because again, state law doesn't even pretend to talk about your stock, and I think that's probably why is primarily it's just so confused. It's very confusing at the end of the day.
Yeah. So Colorado allows you or provides that you can carry a handgun in your vehicle or personal private means of conveyance. It doesn't say anything about the gun being loaded or not. The interpretation of this is that loaded is not important for this definition. Rifles and shotguns, however, and it's in the law down there, 1812-105, cannot be loaded. So understand the difference between the handgun and the rifle or shotgun, and understand you're probably taking on a little bit of extra risk if you decide to carry around your 10.5-inch AR pistol loaded in your vehicle.
Yeah. Do I sound any different?
Um,
Hopefully better. My settings were a little off. The other thing that I wanted to talk about here is I hear this a lot in this section. Permit is valid for a period of 5 years. So once you get your permit, it is going to be valid for 5 years. You have to renew every 5 years. Right here, it says that upon demand, you are to present your permit. This is where we're going to be kind of back and forth here a little bit. Actually, we're going to move forward just a tad bit. So it does say that you have to provide the permit. You have to you have to carry it with you if you're carrying your firearm. Kind of weird because we just read that you don't need a permit if you're in your private automobile or private means of conveyance. But anyways, the permittee shall carry the permit together with a valid photo identification. So basically your driver's license and this have to be basically one at all times during which the permittee is in actual possession of a concealed handgun and shall produce both documents upon demand by a law enforcement officer. Here's where a lot of the issue is with this. That doesn't mean that when you get pulled over, you have to present it. That's not what it means. It just means upon demand. So in other words, you told the officer that you're carrying a firearm. One interesting note is if we go again, we're jumping ahead, 1812-206. It actually says in subsection 3C, except for suspected violations of section 1812-105, 105.5. These are the laws that require you to have a permit if you want to carry concealed. A peace officer may not use or search a database of permittees maintained by a law enforcement agency to establish reasonable suspicion for a traffic stop or when contacting an individual to justify probable cause for a search or seizure of a person or person's vehicle or property. So they can't even search or the database. They can't use it or search it to create reasonable suspicion to pull you over or to create probable cause. So this is one of those confusing things in the state of Colorado. If you tell them about your permit, you have to present it. The other thing, even with your ID, if you read the law of getting pulled over, I believe that's in 1816, I believe, or 18.3. I can look it up for you guys and link it down, or we could talk about it in class. I'm not as familiar, but with those laws as I am with the handgun laws. But even when getting pulled over, you're not required to notify them of anything other than who you are and your address. And maybe Isaac will talk here in a little bit and provide me with the time to kind of find that. And it says, and present identification if available. So it's one of the weird ones for this.
Yeah. So essentially, what we're saying here is that you do not have to present or volunteer information about your firearm in Colorado, even if you're being asked to. All information you get to law enforcement when you are talking about weapons is voluntary. Now, we won't get in right now until into the discussion of whether or not it's a good idea, but it is voluntary. We treat the permit itself as think of it kind of like the driver's license. You need to be able to present the permit if asked while in possession of that concealed firearm. So think of it like your driver's license when you are driving. There's no requirement that you produce that license while you're walking through the mall There's no requirement that you produce the permit while you're not carrying a firearm,
Correct.
a concealed firearm.
Yeah. Let's go to. I'm still trying to find it for you guys, and I do want to read it now. My OCD's kicking in, so I'll look it up. 1812-205. Basically, sheriff's obligations. What they need to do. They're going to take your application. Most of these applications could be done online. The application is kind of like the 4473. It's essentially a 4473. I don't have any big highlights on this. They're going to charge you up to $152.50. The sheriff can charge you up to $100, and currently the state charges $52.50. So your sheriff may choose to charge less, but my experience in the Denver metro area is that they charge the full amount, $100 for their fee, and then $52.50 for the state.
Yeah, there are a couple of exceptions to that. Weld County is practically in the metro area now, but these can change. So any information we give you right now is subject to change. But generally speaking, if you're on the Front Range, you'll be paying that $152.50.
Yeah, yeah.
And if you don't, and if you pay less than that, make sure you get on your knees and thank your local king for the discount on your freedom.
And your freedom, yeah, for sure. Uh, yeah, I don't have anything else. Oh, once you submit all of the information, and that's actually in the next section. So I am kind of jumping ahead. But once you submit all of the information, the sheriff has legally 90 calendar days to either approve or deny your permit. And notice that it says within 90 days, it doesn't say business days. So because it doesn't say business days, it's calendar days of the receipt of all the items specified in 1812-205. So once they receive everything, the application, your payments, the certificate that we provide for you, then they have legally 90 calendar days after that. Anything for you?
Yeah, your weight on this is based almost entirely on how much staff they have. It has almost nothing to do with how your sheriff feels about concealed carry permits.
Yeah.
And I bring that up because a lot of people make the assumption that you're going to wait a really long time to get a permit in Denver, and you're going to get a permit the next day in El Paso County because the sheriff is quote unquote pro-gun or not pro-gun.
Correct.
And that is not true. El Paso County is the slowest county in the state because of the demand and the lack of resources. Generally speaking, lately, I've heard Arapahoe County is pretty fast, even though they're not even remotely pro-gun, quote unquote, in Arapahoe County. So expect to wait based on what the common wait times are for those counties, not based on what you think the sheriff believes.
Correct. Yeah, absolutely. There's not much to this. They have those 90 calendar days. Now, if you are denied, that's in 1812-207. You do have the ability to appeal it. If a sheriff denies a permit application, refuses to renew application, or suspends or revokes permit, the applicant or permittee may seek judicial review of the sheriff's decision. So if you get denied, you have the right to appeal it with the sheriff's office directly, so this is or get the judicial review. So this is your second review. You can completely skip the first review by the sheriff, which is outlined in that 1812-206. So if you are denied, again, you do have the right to appeal it, but then again, you can get a judicial review as well. That's again, if you are denied, you have the right to go before a magistrate instead of the sheriff himself.
So I'm going to put on here the advice I give to people, and you can tell me if this is the same advice you give. If you have something in your background that you're not sure is going to prohibit you from getting a permit, your first step is to get any paperwork together for any charges and dismissal, or not discharges, anything like that, expungement, etc. Read the application carefully, read these sections carefully. And if you're still not certain when you fill out that application that you are being accurate, the easiest, most expeditious thing to do is to call the sheriff's department, have your information ready, and ask them ahead of time. You
Yeah.
may not get a perfectly correct answer, but you often get a better answer than you will if you just fill out the application and go in and then get denied where you probably should have known that you were going to get denied. Once you get denied, you have an avenue for appeal if you really think that they were wrong. But it doesn't hurt you to ask these questions ahead of time of the sheriff's office.
So I wanted to take a step back. I told you that I was going to keep looking at this, and I found it for you guys. Unfortunately, my skills are not all that great. Oh, there we go. Here we go. So 16.3.103. This is in presenting identification and your permit upon request. This is stopping of a suspect. A peace officer may stop any person who he reasonably suspects sexist. So if it's a lady cop, guys, you got to tell her, nope. The law says only he. Uh, a person who he reasonably suspects has committed, or is about to commit a crime, and may require him to give his name and address, identification if available, and an explanation of his action. So this is if you get pulled over, all of that stuff. The stopping shall not constitute an arrest, all of that stuff. So this is 16.3.103, 16.3.103. It was important for me to bring that up because a lot of people get this confused. They think that because it says upon request in 1812-204, that as soon as you get pulled over, you must notify the sheriff's office that you have a gun. And that's just not the case. In the state of Colorado, you don't have to tell the cops that you have a gun. It's not part of the laws. It's not, there's no duty to inform in the state of Colorado.
So the question that often comes along with that is, do they already know when they pull you over?
Yeah, and that's kind of what we talked about earlier in 1812 206. In 1812-206 in subsection 3, remember that it says, first off, up at the top in A, it talks about the database. They can create a database, and that's really more for accountability to make sure that they are not denying too many humans. If you read in B1, right in this section here, in B1, it says that they actually cannot have a database. And in fact, they have until July 1st, 2011, they had to remove statewide database. So any information that they have of concealed handgun permit holders, they cannot share it with other agencies, cannot share it. And if for some reason they did, say for felony stuff or for legal, legitimate stuff, they shared the information, they have to get rid of it. And then we go back to that C, which we read earlier, except for suspected violations. So again, only if they suspect that your permit isn't valid or they're trying to see if your permit was valid. But the only reason they would know you have a permit at this point is if you were the one that told them. Notice nowhere here it says you must tell the cops that you have a permit or that you have a firearm. It did say upon request, but it doesn't say you have to provide the information that you are carrying a firearm or that you have a permit. And that's going to be in 1812-206, where it actually prohibits them from even using or searching the database of permittees.
So to add to this, the date, the 2011 date is important because there was a lawsuit filed in Colorado that discovered that certain law enforcement agencies were keeping records of this and were admonished by the court and ordered by the court to remove those databases or other records. And the reason why this is important is because we're still within the living memory of this happening, and we will occasionally get people who will ask the question in class, well, I know somebody who said that they got pulled over and the sheriff knew they had a permit. It did happen in the past. By law, it is not supposed to continue to happen.
Correct. and it may still be happening, but again, it's up to you to
Mhm.
fight this stuff.
Right.
This is just what it sounds like. Colorado Bureau of Investigations and their duties. So once they receive the information, the Colorado Bureau of Investigations is going to do their background check. The sheriff does their own lengthy background check, but that's basically all this is doing right here. One thing that I do know for a fact, and I found this out when we had our FFL, is that they are actually pretty true to their word when they say, I know some of you guys are like, that's not true, conspiracy, and the earth is flat, and all you weirdos. Um,
Not flat.
it's
Dome.
not flat. Of course, it's not flat, but the conspiracy theories, and I by no means like the overlords and government, but I have been in a position where I actually needed numbers for a transaction that was done for a gun sale. And I forgot to write the numbers down. They provide you with two numbers. They provide you with the federal number and the state number. And I just didn't write them down because lazy. And I called them up and they're like, I don't know what you want me to tell you, but we have to purge this information within 24 hours. So I had to figure it out on my own. So in here, it kind of talks about what they do and all that stuff. But they also get rid of the information because legally they have to, because there's no gun registration in the state of Colorado. Illegal to register guns in the state of Colorado. 1812-209.
Hold on a second.
Yeah, go.
On that Bureau of Investigation, they do check the medical
Oh, the
marijuana
marijuana. Yeah.
database as a part of that CBI check.
Yeah. Yeah. So yeah, for all you potheads, they do cross-reference with that because both of these permits are issued through the CBI, so they will cross-reference. Not recreational though. So if you're recreational, there's no way really for them to find out.
Yeah, a lot of people will make the assumption that just because your ID has been scanned at the pot shop, that the state of Colorado knows that you're buying weed now. That scan of your ID is to validate that it is in fact a valid ID. Some liquor stores do the same thing.
Correct.
So this Colorado Bureau of Investigation check is for medical marijuana cards.
Yeah.
Yeah.
Now the ID scanning, they also do it for skipping because you're only allowed to buy a certain amount. So so you don't go from pot shop to buy. Not that we know, but we've heard.
Also, the prohibition is not on buying marijuana; it is on using marijuana.
Yeah. And that could be found in 1812-106, 1812-106, where it says you may not possess a firearm while under the influence of intoxicating liquors or controlled substances. But again, read that in 1812-106. 1812-209, 1812-209 basically says that you have the right to get a temporary emergency permit if you have some sort of restraining order or something similar to that. It doesn't necessarily have to be a restraining order. You may receive a temporary emergency permit. This temporary emergency permit could be obtained at the age of 18. Something that's different than the regular permit because that's at the age of 21. So this one at the age of 18, you can do that. The background check is also done a little bit quicker, and it's only $25. Cannot exceed $25. So for those of you that are interested in, well, I guess you wouldn't be interested. You need an emergency permit, or you know somebody that's 1812-209. Anything you want to add about
that emergency permit is valid for 90 days.
90 days.
It can be renewed, but it is not obviously a 5-year permit.
Correct. Yeah. 1812-210, 1812-210 maintenance of permits. Basically, if you move within 30 calendar days, you must notify the issuing sheriff that you have moved. So if you move from apartment A to apartment B, you still have to notify your issuing sheriff legally, according to this, that you have moved. Now, if you move to a different county, you would not go to the new county until it's time to renew your permit. This is just updating your address. If your permit is lost, stolen, or destroyed, um, you have um, you have 3 business days, 3 business days to let them know that your permit is lost, stolen, or destroyed. And from the moment you realize that it's lost, stolen, or destroyed. So, and that is 3 business days. So notice the difference in 330 days. And when they want it to be business days, they're very specific in adding business days to it. So be mindful about that stuff. So 30 days if you move, 3 business days if your permit is lost, stolen, or destroyed. If your permit is lost, stolen, or destroyed, they will charge you $15, or they can. Some sheriffs will choose not to do that, but some of them will charge you the $15 because you lost it, it was destroyed, or it was stolen.
Yeah, and this is not a renewal of your permit or anything. And oftentimes for the address change, it's a simple form, takes a few minutes to fill out. So this is not the whole process over again. You're just letting them know that you've moved and you need a new one or you lost it.
Correct. 1812 to 11. This is renewals. For me, the renewal is the big one for me is the requirements for renewal. First off, you renew every 5 years. You have within 120 days prior to the expiration of the permit, you need to start the application process to renew it. They don't want you to start 121 days before, but within 120 days. Many sheriffs are illegally requiring permittees to take another class. If you're renewing, you do not need to take another class. Notice that the requirements, it says a notarized affidavit stating that a permittee remains qualified pursuant to the criteria specified in subsection 12203, 1A to 1G. So to renew, you have to still qualify and still be eligible under 1812-203, 1A to 1G. Now, I am going to go back here because if you guys remember, the training requirement in the state of Colorado, 1812-203, let's go back, doing one more, 1812-203, criteria to obtaining a permit. The training requirement is H. So to renew your permit, you only have to be still qualified under G. You never again have to take another class as long as you continue renewing. So as long as you continue renewing in the state of Colorado, remember 1G is where it ends, not 1H. This is one of those things where your sheriff's office is going to be like, well, I don't care what the law says. I feel that you should take another class. Listen, I think you should take another class for sure. I don't think you're training enough. It's not what I believe, though. It's what the law says, and the law does not require you to take another class. Outside of that, if you fail to renew, they give you a 6-month grace period to renew. And in that 6-month grace period, you do not have a permit. You're technically not a permittee. And when you go renew, they can charge you a late fee, the $15 late fee.
Is it 15 or 25?
15. So
Okay.
it says a permittee who fails to file or renew a renewal form on or before the permit expiration date, renew by paying a late fee of $15. A person whose permit has permanently expired may reapply for a permit. Now, if it permanently expires, you're a new applicant, and at that point, you would need to take the class again. At that point, if it's been more than 10 years, if it's been more than 10 years. Anything on that for you?
Yeah, the background check fee.
Oh yeah, go for it.
Background check fee for a renewal is it 13 or 18?
So for the state, for the county, it could be no more than $50.
Mm-hmm.
And currently the state charges $13, so no more than $63.
Yeah, so your renewal fee cannot exceed $63.
Yeah. as of right now, because remember, the state of Colorado does not have a limit on what they can charge, but
Right.
counties do.
Yeah.
18, 1812, 212, exceptions. This part two shall not apply to law enforcement officers. It's stuff that really doesn't have to do with us, so I'm going to skip it unless you have anything to say about this.
Nope.
Yeah,
Except that
but
there are different classes of society, I
yeah,
guess.
there's different classes of society for sure. Yeah, some people have more freedom than others. Uh, 1812, 213, reciprocity. This one has been one of those weird ones. If you want to know your the reciprocity states that have honored our permit, I encourage you guys to go to this website right here. This website right here is the Colorado Bureau of Investigations website. If you go under the firearm section, you will be able to see the official list. It's 33 at the moment. 33 states. Everything on the left is a yes, everything on the right is a no. These states will honor your permit. Basically, you can carry your gun in their state as if you had their permit, but you have to follow their laws. Obviously, you would have to follow their laws.
Yeah, examples like duty to inform, carrying in bars, where
Yeah,
signs apply, all that stuff.
all that good shit. One other thing that I've been talking a lot about reciprocity because people have been wanting to talk about multi-state permits. I know you're doing Utah classes now. One thing to kind of note here, and most states have this, for those of you that are interested in having non-resident permits, because you think it's going to get you other states, make sure you read the laws of that state. In the state of Colorado, it says a permit to carry a concealed handgun or other concealed weapon that is issued by a state that recognizes the validity of permits issued pursuant to this part two shall be valid in this state in all respects as a permit issued pursuant to this part two. If the permit issued to a person who is if the permittee issued to a person who is 21 years of age or older and a resident of the state that issued the permit. So a lot of people will want to get the Nevada non-resident permit because they want to go to Washington State. The problem with that is Washington State has a very similar law where you have to be the resident of the states that issued the permit. So making most non-resident permits actually invalid. So if you do have non-resident permits, just make sure that the state you're traveling to does not have this section right here, like the state of Colorado does. In most of the states that I've done concealed carry classes in, Florida, going to Arizona has the same thing. Um, Wisconsin, all of that stuff, all has very similar language, which is why they honor our permits. So most non-resident permits actually are completely useless because of that little caveat right there.
So just to clarify, if you had a resident permit in Nevada, you live in Nevada, you got a concealed carry permit in the state of Nevada, then you can travel to Washington and carry in that state. But
Correct.
if you have a non-resident permit from Nevada or Utah and you travel to Washington, it will have a law similar to this saying that your permit is only valid if you are a resident of the state where you got the permit.
Correct. Yeah, absolutely. One of those weird ones. Um, one of those silly ones again.
This is all an example of when we say like people who carry guns tend to know the law better than anybody else, and yet we get treated like we don't.
Yeah.
We go into this kind of detail. So,
This one got complicated 1812-214 as of 2021. It became a little bit more complicated and because we lost preemption. So this is the section where it told us where we can and cannot carry. So this used to be a much shorter section. Now it got extended a little bit more. They added this section right here. It says a local government, including special district or the governing board of an institution of higher education, including the board of the directors of the Aurora Higher Education Center, may enact an ordinance, resolution, rule, or other regulation that prohibits a permittee from carrying a concealed handgun in a building or specific area within the local government's or governing board's jurisdiction. So again, this has been confusing. Is if it's under their jurisdiction, um, they can basically prohibit where you can and can't carry within their buildings and property and all that stuff. It doesn't take away from private individuals. It gets a little tricky with all of that stuff. Also, if we go down to, is it the second to last sentence? Right down here. I don't know if you guys can see the cursor, but anyways, oh, there we go. This right here. For a first offense, the ordinance, resolution, or other regulation may not impose a fine that exceeds $50. It may not impose a sentence of incarceration. A person who does not leave the premises when required may be subject to criminal penalties. Now, I do want to go to 29, 11.7. And
while he's navigating there, I want to point out that one of the big problems with this law is the number of individual jurisdictions. So only speaking about cities, towns, and counties. We're not even talking about special districts or institutions of higher learning, just cities, towns, and counties. We have 336 individual jurisdictions in the state. For instance, El Paso County has something like 9 or 10 cities within the county. And each of those cities could make their own laws under this statute about places where you are not allowed to carry a concealed firearm.
Right. And down here it says a local ordinance, regulation, or other law governing the sale, purchase, transfer, or possession of a firearm, ammunition, or firearms component or accessory may only impose a criminal penalty for a violation upon a person who knew or reasonably should have known that the person's conduct was prohibited. So it's one of those weird sections where you should have plugged your ears before I said this, because ignorance of the law could have helped you here. Since we're here, I do want to talk about unless otherwise, this right here, unless otherwise expressly prohibited pursuant to state law, which there are sections where it expressly prohibits this. So go find that in 29 as well, or go find that in our constitution, the state constitution as well. Unless otherwise expressly prohibited pursuant to state law, a local government may enact an regulation, or the law governing prohibited the sale, purchase, transfer, or possession of a firearm, ammunition, or firearms component or accessory that a person may lawfully sell, purchase, transfer, possess under state or federal law, the local ordinance regulation. So this is a lot of words that seem scary, but at the end of the day are actually mean nothing, because the Bruin decision, right? Rocky Mountain gun owners has sued them, and that kind of, because of the Bruin decision, a lot of this went away. Boulder had enacted a law. They kind of retracted that stuff. Louisville tried to pass a law, and they kind of retracted a lot of this stuff. So a lot of lawsuits going on at this given moment. So be mindful about that stuff. As of right now, most of this means absolutely nothing. And at the same time, just because one city, say Denver, prohibit, and I'm not saying it is, I'm just saying, just as an example, Denver prohibits you from buying certain ammunition, it doesn't mean that you can't own it. You just can't buy it in Denver and possess it in Denver. It doesn't mean you can't do it in a different place. Most cities, city laws, local laws, only apply to residents as well. So be mindful about that stuff. For those of you that are interested in those laws, go to library.municode.com. Library.municode, municode.com.
So on this note, I would strongly encourage you to take some action to support organizations that are actually having these fights. The reason why Edgar can say that these laws, generally speaking, don't mean anything is because of the work of organizations like Rocky Mountain Gun Owners. So don't just sit there and complain about this stuff. It takes money to fight these cases and to defend your ability to have a gun. And I strongly encourage you to, after you've gotten done feeling sorry for yourself, actually do something about it.
Right.
Guns for Everyone has been asked many times, what are we doing? This is not what we're good at, but we will point you to the people who are good at it. We focus on the training, and we encourage you to go support organizations that are winning the lawsuits and helping to defend this. So, yeah.
Absolutely. Continuing with 1812-214, it is important to talk about, because the name of this law is authority granted by permit, and easy, none. You are not granted any authority by this permit. A permit to carry a concealed handgun authorizes the permittee to carry a concealed handgun in all areas of the state, except as specifically limited in the section. A permit does not authorize the permittee to use a handgun in a manner that would violate a provision of state law. A peace officer may temporarily disarm a permittee incident to a lawful stop of the permittee. Of course, this is if you tell the cop that you are carrying a firearm. Remember, it doesn't say when you get pulled over you must tell the cop. That's not what it says. Incident to a lawful stop of the permittee. The peace officer shall return the handgun to the permittee prior to discharging the permittee from the scene. So we already read the local government stuff. If a local government or governing board prohibits carrying concealed handgun in a building specified area, the local government or governing board shall post signs. So this is for governments. Notice it doesn't say private entities, it says governments. Be mindful about that stuff. Private establishments do not have a requirement to post a sign to prohibit you from carrying a gun. You can go to any private establishment, and if they don't want you to carry a gun there and they find out, they can ask you to leave at any moment. You won't be arrested. You're not, in general, you're not in violation of the law at private establishments. But local governments, if they want to prohibit guns, they have to have the sign.
Yeah, and if you read this carefully, the law here is commanding that they post a sign. The law here is not commanding you; it is commanding them. And the reason why that's an important distinction is because in some states, when a sign is posted, then it is on you to follow the law, and you still need to follow the law and understand that carrying into these public places that it's prohibited is against the law. But the sign law here is an imposition on the building, it's or the governing agency here, and it's a little bit confusing, but it's important because when people talk about sign laws, usually what they mean is you have to follow the sign, and that's not the case here. Even though you're not allowed to carry in here, they are the ones required to post the sign.
Yeah. A permittee issued pursuant to Part 2 does not authorize a person to carry a concealed handgun into a place where the carrying of a firearm is prohibited by federal law. The only exception to this is, well, and it wouldn't be an exception because it wouldn't be prohibited by federal law. So it's important to note that it is not against the law for you to carry onto national forests and national parks. What that law says, the homie Obama gave this to us back in 2009. It came into effect. What was it? The 20th of February of 2010, something like that. You can now carry onto national forests, national parks, but it has to be done so according to state law. So if you're in Colorado, you're at Rocky Mountain National Park, you follow Colorado state law. If you're in California and you're in Big Bear or Bear, whatever park they have, nobody cares about Cali anymore. You can take your finger gun, pew pew, because that's all you're allowed in California. So on and so forth, so on and so forth. So outside of that, what's prohibited by federal law is your standard stuff, federal property. A lot of weird people say county courtrooms. County courtrooms are not federal jurisdiction. City courtrooms are not federal jurisdictions. Only stuff that is federal property can't carry your gun here.
Banks are not federal property.
Yeah, I don't know why a lot of people think that banks are federal property. Banks are not federal property.
What if it's called Federal Credit Union?
It's still privately owned organization.
Yeah, banks are not off limits. One important distinction is that post office parking lots are excluded for possession of a firearm. And that law is kind of old now, but back when we first started this, it was relatively new. You cannot take the firearm even into the parking lot of a post office. The other places, military bases, you're generally not allowed to carry. If you are allowed to have a firearm on a military base, it's because you've gotten special permission from the base commander. Your concealed carry permit is not special permission to carry onto a military base.
This one was added in 2021. Again, unfortunately, because we lost preemption, statewide preemption. Preemption being state level protection of the laws. We lost that with this. So 2.5 was added, basically saying that if local governments add their laws, that is a valid thing. Unfortunately, a permit issued pursuant to this Part 2 does not authorize a person to carry a concealed handgun onto the real property or into improvements erected thereon of a public elementary, middle, junior high, or high school, except that a permittee, notice that it says a permittee, may have a handgun on the real property of the public school so long as the handgun remains in his or her vehicle. And if the permittee is not in the vehicle, the handgun is in a compartment within the vehicle and the vehicle is locked. One thing that I encourage people, especially an hour into the video, is don't overcomplicate what the law says. I get this a lot in classes where we'll read this stuff and it says, oh, okay, well, it says that the compartment within the vehicle and the vehicle has to be locked. So do I need to lock the compartment? Well, that's not what the law says. Don't overcomplicate it. It's very simple. Just read it what it is. The handgun is in a compartment within the vehicle and the vehicle is locked. Don't add to it. Don't take away from it. Don't overcomplicate it in your head. I know a lot of you guys that like to overly plan your days and be very detail oriented, like to add a bunch of stuff that's not in here. Don't do that to yourself. It is what it is. It says what it says. No need to overcomplicate it. Now, one thing we haven't mentioned yet, and important to kind of note, maybe this is one of the quizzes that we give you to make sure you're watching the video, is that you read annotations, and annotations will many times give more explanation or sometimes even change what the law actually means, give rules to juries, that type of stuff. So read the annotations as well. We probably should have said that at the beginning, but now we have a cool little quiz. Anyways, B, a
Only
permittee.
people who have gotten this far would have taken that information seriously anyway.
Correct,
So,
correct. Yeah, for sure. A permittee who's employed or retained by contract by a school district or charter school as a school security officer may carry a concealed handgun onto the real property or into any improvement erected thereon of a public elementary, middle, junior high, or high school while the permittee is on duty. Again, just what it sounds like. If you're employed or retained by contract and you're a school security officer for a school district or a charter school, you can now carry concealed while you're on duty. C, basically undeveloped real property owned by a school district that is used for hunting or other shooting sports. It'd be weird if they had
a
property,
shooting range.
shooting range that doesn't allow guns.
Yeah. So A, B, and C here are tied to the National Safe Schools Act. I can't remember if that's the exact name, but that goes back to the mid-90s. You can't take a gun onto school property unless you are specifically authorized by your state, and that's why the word permittee is used here. The implication being that you are authorized by the state to take a gun into a school zone, but you have to follow these specific rules, which are essentially keep the gun in your car and lock your car while you're not in it, keep the gun in the compartment while you're not in it, or if you're specifically authorized as a security guard.
So it's you said something, triggered something in my brain, so we're going to talk about it. A permit to carry concealed handgun authorizes a permit to carry concealed handgun in all areas of the state except as specifically limited in this section. There is a section in the transportation section. If you go into the laws in the transportation section of the law, where it says that you cannot carry a handgun. So a lot of people think you can't carry into the airport or bus stations and stuff like that. It says, and it says you can't carry a handgun unless you are authorized to. Well, if you have a permit, you are now authorized to do so. It was you talking about authorization and stuff like that that made me think about that. Um, so yeah, you can in fact go into bus stations and stuff like that carrying concealed, because you do have authorization for that stuff. 3.5. This one's tricky because it says, and when I say tricky, I don't mean it's complicated. I mean it's meant to fool you, as many laws are, because it implies that you're not allowed to carry onto college grounds or university grounds, and all it says is if they have passed any laws. A permit issued pursuant to this Part 2 does not authorize a person to carry a concealed handgun onto the real property or into any improvements erected thereon of a public college or university if the carrying of concealed handguns is prohibited by the governing board of the college or universities. Hasn't happened yet. It doesn't mean it won't happen, but this is one of those things where I think, anyways, maybe I'm just tarded. But kind of written in a way where it makes you believe, excuse me, that you're not allowed to carry there.
Yeah,
See
it
you
goes back
Regis
to
does not pass this.
reading the entire statute.
Yeah,
And if you walk into a public university and you see a no gun sign on the window, again, that doesn't mean you can't carry there. You'd have to actually go and read the governing documents of the college or university to see if it is specifically prohibited. I would not encourage you just to ask an administrator if you can have a gun on campus, because the answer will be no. But that doesn't mean that you can't. So
correct.
do your due diligence. If you're a student and you're on campus and you want to be able to carry, go read the governing documents for the
Correct.
specific college or university. Not, don't read CU Boulder if you go to CSU Pueblo. You have to
Correct.
read the right one.
Correct. And sometimes the CU regents who are kind of in charge of all of them will kind of make a blanket for everyone, but this just kind of gives it the power to each individual college and university at this point. 4, a permit issued, and this is the last place where you cannot carry. So far, the only places at a state level where you cannot carry is where it's prohibited by federal law, public schools K through 12, with the exceptions that we talked about. And then now the last and final place where you may not carry in the state of Colorado does not authorize a person to carry concealed handgun into a public building at which security personnel and electronic weapon screening devices are permanently in place at each entrance to the building. Security personnel electronically screen each person who enters the building to determine whether the person is carrying a weapon of any kind. And this is where it gets complicated, because security personnel requires each person who's carrying a weapon of any kind to leave the weapon in the possession of security personnel while the person's in the building. So technically, if you go to Pepsi Center or Ball Arena now, and they have the metal detectors and you have your gun on you, you could say, hey, cool, where could I leave it while I'm inside of the building? And they have to provide a locker or a safe place for you to store that firearm. If not, it doesn't technically meet the requirements. Obviously, that puts you in a predicament where if they don't have it, you could be like, well, I'm allowed to carry my gun there. Ball Arena being a private establishment could very easily be like, well, you're denied entry. Where that may help you a little bit is local governments. Now, I get it's confusing, but local governments that haven't prohibited the carrying of firearms, and maybe they don't have security guards or metal detectors, doesn't fall into that. You would be able to carry there as well. So it's a complicated conversation. One thing that I also want to say, just to complicate stuff even more, it's not just public building, it's public area as well. Red Rocks is a good example of this. Red Rocks, anybody can go there, go work out, go do their pictures, go do their TikToks and all their silly stuff. But when there's a concert, they control entry into that venue. And now they have security personnel and electronic weapon screening devices at each entrance to that area. So it's not necessarily a building. Festivals, fairs, and stuff like that, they kind of do the same thing. 5, nothing in this part 2 shall be construed to limit, restrict, or prohibit in any manner the existing rights of private property owners, private tenants, private employers, private business entities. Essentially, private property rights are more important than your gun rights. If a private property owner asks you to leave, you're not under arrest. You haven't violated any laws, but they are, in my opinion, rightfully so. It's their property. They can ask you to leave. But it's not an illegal thing until you refuse to leave, in which case now you're trespassing. You got anything?
One of the common areas where people feel like a public building is a public building is places like hospitals. For instance,
Yeah.
Colorado Springs Memorial Hospital has, the security guard and metal detector at the emergency department, but
Correct.
not at the main entrance to the building, nor is it a public building. It is a private property. So obviously you're not going to be able to get through into the emergency department with your gun, but the front door is open. There are security guards, but no metal detectors anyway. And it's not a public building. So
Correct.
kind of thinking a little critically about what actually constitutes a public building versus a private building that is open to the public.
Correct. The 1812-215, let's read that one. Immunity, again, this is for that special class of citizens. This does not apply to you guys who have less freedom than other certain citizens. And then 1812-16 was repealed. So nothing to read there. I think we should. It might be good. I'll let you kind of decide if we talk about self-defense stuff.
Yeah, I think just the high level stuff. Our law focused class kind of goes goes into detail about how that process works. So I think that conversation is better had in the classroom.
Correct.
But it's worthwhile to just review these statutes to understand what Colorado's specific statutes are.
Right? Yeah, absolutely. So let's again, the website, I'm going to put it up again just for you guys. That's lexisnexus.com/hot-topics/Colorado. Again, that www, super duper important for the URL. Fuck it, just because I'm here. My name is Edgar Antillon, Guns for Everyone. The other guy, his name is Isaac Chase.
Man, I thought we were thought we were restarting the video or something.
Oh yeah. No,
I stopped paying attention for 2 seconds, and I was
2 seconds. You're like, what? No, we're not restarting.
Okay. I was navigating, and I'm like, what is he talking about?
Yeah. I don't know. I feel like some people are trying to cheat and like coming in now.
Oh yeah,
Like skip the video. Let's just move forward.
You're only hurting yourself.
Yeah. For those of you that are interested in self-defense laws, again, we're just going to do the highlights. Go to 18, Title 18. Go to Article 1, and then you would go to 7, justification and exception from criminal responsibility. The main ones is 704 and 704.5. 704 and 704.5. 704 is basically everything that happens outside of your house, literally outside of your house. Your front yard, literally outside of your house. Your backyard, literally outside of your house. Your car, literally outside of your house. I know some of you guys are probably like, well, but I heard that your house is an exemption of your home. It's an extension of your home. It's not an extension of your home. There's nothing in Colorado law that says it's an extension of your home. A lot of people, I think,
your home is a thing in other states, but correct. In Colorado, your car does not. There is no relationship there.
Correct. I think a lot of people confuse it because you can carry your gun in your vehicle essentially the same way you would do in your home, but your self-defense laws are different for each individual one. So 181.704 says that in subsection 2, deadly physical force. Now, in our classroom, in our classes, that's a handgun. but it doesn't say handgun. That's super duper important for you guys to understand. It is not specific to a handgun. It says deadly physical force. And now you can read what that means. Again, go down to the annotations. I mean, it might tell you what it means there. I don't think it actually provides a definition anywhere on here. I don't think there is an actual definition for that stuff. Even though the section's called definitions, I don't think it gives you an exact definition of what that is.
If you want a functioning working definition of deadly force, deadly
Physical.
physical force, go enroll for law school,
Law school, yeah.
and become a criminal defense
Correct.
or prosecutor,
Yeah.
attorney, and spend your life dedicated to understanding this
Correct.
specific phrase, because it's not simple.
So deadly physical force may be used only if a person reasonably believes that a lesser degree of force is inadequate, and the actor has reasonable grounds to believe and does believe that he or another person is in imminent danger of being killed or of receiving great bodily injury, or the other person is using or reasonably appears about to use physical force against an occupant of a dwelling or business establishment while committing or attempting to commit burglary as defined in sections 18.4.202, 18.4.204. The other person is committing or reasonably appears about to commit kidnapping as defined in section 18.3.301 or 18.3.302, robbery as defined in section 18.4.301 or 18.4.302, sexual assault as set forth in sections 18.3.402 or in sections 18.3.403 as it existed prior to July 1st, 2000, or assault as defined in sections 18.3.202 and 18.3.203. So we always simplify this to threat of death, serious bodily injury, kidnap, and sexual assault. Highly encourage you guys to go read sections 18.4.301, 18.3.203, 18.3.301. Go read all that stuff, and what you will see is that robbery isn't simple theft. A lot of people think that robbery is somebody took your stuff. No, it's they threatened you with a tool, with a weapon to take your stuff. So there goes the threat of death or serious bodily injury. Kidnap and sexual assault. Those are the four that we kind of generalize it down to. Just because all of that stuff, if you read it, it falls under those four: threat of death, serious bodily injury, kidnap, sexual assault. Anything you want to?
Yeah. So the reason why we narrow it down to death, serious bodily injury, sexual assault, or kidnapping is to simplify in your mind the question of is all of this worth what you think you're stopping? While there is some allowance in here for things like burglary under 18.4.202 or 4.204, the nuances here are so open to interpretation that if you are determining your actions based on what the law says right here, your chances of nailing this perfectly are slim to none and not worth applying your understanding of deadly force to. That, if you are defending yourself with an attorney afterwards, his job is to go through here and try to understand this and present your case. But nothing is worth dying for or going to jail for that doesn't involve saving a person's life or limb. So that's why we essentially boil this down into those four circumstances.
Yeah. The law says if a person reasonably believes a lesser degree of force is inadequate. Excuse me. We do not have a duty to retreat in the state of Colorado. In fact, down here it says doctrine of retreat is from common law. There is no statutory provision regarding the duty of a person to retreat before countering the use of force with force. The doctrine derives from common law. And it gets explained a little bit more. We don't have the duty to retreat in the state of Colorado. But again, the law does say, in essence, you using deadly physical force has to be the last resort. It's because something else was inadequate. So if you can backhand the person, if you can flick them, spit in them, blow a kiss at him and it stops the fight, then do that first. Obviously, there's going to be many situations. Well, hopefully you never encounter this, but there's evidence of the gun was first and final option because there was no lesser degree of force, and that's a better way of saying a lesser degree of force versus option one, option two, option three. Um, it's there was nothing else I could have done in this situation other than using deadly physical force. Again, in our class, it's the handgun, but if you're in a knife class, it's a knife. If you're in a bat class, it's a bat. If whatever it might be, right? So it's deadly physical force. Um, Anything you want to add to this?
Not before you get to the initial aggressor stuff. So, or were you going to cover that?
Oh, yeah. No, let's do that. I'll let you do that.
Okay. So just very quickly, you don't have legal standing for use of deadly force if you were the initial aggressor. In our legal class, we kind of go into this in a little bit more detail, but simply put, you cannot be the one who threatened the use of force or used the first physical force against somebody else, and still be able to use lethal force against that person. So there is the initial aggressor law. If you're not familiar with that, it would be worth your time to spend some time researching initial aggressor. And of course, if you guys engaged in a physical fight that was agreed upon, like WWE in your backyard, if the fight is a result of combat agreement, you do not have an argument for lethal force.
Correct.
And we don't have mutual combat laws, but we're just, what this law means is if you guys agree to a fist fight, lethal force can't be part of that.
Yeah, and all of this stuff is going to be in the annotation. So, like as you were talking, most of what you were saying was kind of coming up in determining whether initial aggressor jury instructions is appropriate. The other ones is a self-defense instructor should be given. Instruction should be given when there is any evidence, including circumstantial, that a defendant acted in self-defense. All of this stuff is a lot of the stuff that the juries are going to have to receive, but it's still good information for you guys, so you guys kind of understand a little bit about what the juries get and rules in courts and stuff like that. When an initial aggressor withdraws from an encounter, so if you start the fight and then mid-fight you're like, I'm an idiot, I shouldn't be doing this, you kind of get your affirmative defense back. So there's that as well. Belief that lesser degree of force is inadequate must be reasonable. So it talks about that. So a lot of that stuff is better explained through all of this stuff. And if you're a nerd like both Isaac and myself, then you would go to this and read it and see what it says, to kind of understand it a lot more, because that's the case law on all of that stuff. So
yeah, so essentially the thing that you should take from the last 5 minutes of conversation here is that trying to justify your actions in the moment based on what you think the law says is ridiculous if you understood how complex this is. And we talk about this in our classes, the concept of could versus should. Don't look at this law as a license to act. Look at this law as a criminal defense once you have acted in self-defense.
Correct. Anything else before we move on?
Nope, that's good.
Yeah. Use of deadly physical force against an intruder. A lot of you guys know this as the quote unquote make my day law. This one is, again, one of those laws that is heavily misunderstood. A lot of people add to it without needing to add to it. The General Assembly hereby recognizes that the citizens of Colorado have a right to expect absolute safety within their own homes, within your own home. It doesn't say your neighbor's home. It doesn't say your grandpa's home. It says within your own home. In homes includes home is where the heart is, right? That's the cheesy cliche stuff. So it could be your apartment. It could be dwelling is really what it starts to talk about. So the word dwelling is where you habitate, So a lot of people come to class and they say, well, I live in my car, and then I'm the ass that says, no, you don't live in your car. It is impossible for you to live in your car. And they're like, no, I do. I'm like, no, you sleep in your car, but you use the restroom at a restaurant, you shower at the gym, you cook in the little grill outside of your car. In my house, I dwell there. I live there because I can habitate there. I don't necessarily need to leave the house to live, and I don't, unless I have to. So we're talking about a dwelling here.
So I
Uh,
want to add. I want to add to that. If you go read the case law, you will read cases where arguments are made for what constitutes a dwelling. And if you are going to go outside what is typically considered the dwelling, meaning the home, the apartment, uh, think of those as arguments that will need to be used to convince a jury that whatever you were occupying did constitute a dwelling. Um, that argument may work or it may not work, but the only type of dwelling explicitly um, excluded under Colorado law are correctional facilities.
yeah, and there's a story for that, and you guys can go read it.
Yeah, and you should.
You should.
It's entertaining.
You should. But anyways, notwithstanding the provision of subsection 1, I'm sorry, subsection 1704, any occupant of a dwelling is justified in using any degree of physical force, including deadly physical force against another person when that other person has made an unlawful entry into the dwelling and when the occupant has a reasonable belief that such other person has committed a crime in the dwelling in addition to the uninvited entry, or is committing or intends to commit a crime against a person or property in addition to the uninvited entry, and when the occupant reasonably believes that such other persons might use any physical force, no matter how slight, against any occupant. So many myths. The person has to be attacking you and you must be under threat. Nope, because you can defend property here. Not what we recommend. I would never recommend you increase your risk for a TV. You got to understand that when you're saving TVs, you are increasing your risk of death. Why would I recommend you increase the level of risk for your life over a stupid TV? But inside your house, you can defend your dog, you can defend your couch, all of that stuff. Outside your house, you cannot defend your dog. Outside your house, you could only defend other humans, other people. Inside your house, you can defend anything really that's within your house.
Yeah,
Also,
just to clarify what you said there. Lethal force to defend. So like if your dog gets attacked, you can grab the other dog and punch him in the nuts. But there we don't have
or get a dog that
defense for
wins.
lethal force to protect the dog.
Yeah, or get a better dog.
Yeah.
Um, and here's again going back to the case notes and going to the annotations. A defendant must establish by preponderance of the evidence. Now, preponderance of the evidence is what is most likely to be true. That's a preponderance of the evidence. That he or she had a reasonable belief that the intruder was committing or intended to commit a crime against a person or property in addition to the uninvited entry. This is the good sentence here. This inquiry focuses on the reasonable belief of the occupant, not the actual conduct of the intruder. So when we read the law, it kind of gives you some stuff, but when you read the annotations don't care. It actually specifically says we're going to believe the homeowner based off of what is most likely to be true, and also we're not even going to pay attention to what the intruder was doing. We're going to base our decision based off of what the occupant reasonably believed was going on in that particular circumstance. So no, they don't have to be attacking you. They don't have to be facing you. Again, read the law. Nowhere in the law does it say they have to be facing you, and no more than 90 degrees away from you. Like it doesn't say any of that stuff. It says what it says. That's it. And the only thing that you should add to it is what's down in the history and the annotations. 3, you are immune from criminal prosecution for the use of such force. Subsection 4, you are immune from civil liability for injuries or death resulting from the use of such force. That's the other thing. A lot of people say, "Oh, you should kill them because they're going to sue you." First of all, even if you don't kill them, you do kill them, you can still be sued outside of your house. Um, Dead man tell no tales, but forensic science does. I like it when those people come in and they're like, "Well, dead man tell no tales." Like, yeah, but your neighbor's Ring doorbell system does.
Yeah. If you
For
come into our class saying "dead men tell no tales," then we're going to know you didn't watch the video.
yeah, uh, don't say it because now I'm gonna have to not sign your certificate
Now I'm going to have to
uh,
remember that at the
at the
trial.
end. Yeah. Uh, so you're immune from civil liability and you're immune from criminal prosecution under the under 18.1.704.5, the use of deadly physical force against an intruder. Um, I don't know what else you wanted to say about
Yeah, a
this.
couple of things about this. First of all, when people read this unlawful, other person has made an unlawful entry into the dwelling. Of course, once the person is inside, we have a very strong standing to say has made an unlawful entry. According to not just case law, but prosecutorial norms, there are cases where somebody was trying to make entry, like
Yeah,
coming through a window. Um, the interpretation of has made an unlawful entry is an interpretation. If you try to make the argument that they had unlawfully entered and they had not yet fully entered, you could lose that argument. So don't take this as a license to say, well, they were trying to come in, so that means this law applies. It may not. Again, we don't use this as a license to act. We use this as a criminal defense after the
correct.
fact. The
Uh,
other thing, oh, go ahead.
yeah. With that, not to contradict that because that's
Mhm.
good. Like just it's we in a home defense situation we would recommend a number of things before you actually use your pew pew. But the law does say that you have the right to expect absolute safety within their own homes. And that's really how a lot of humans who have shot people as they were coming in kind of get the quote unquote make my day law,
Mhm.
because you have the right to
Right.
feel absolute safe within your own
Right.
home.
And so I'm not making the argument that you should not shoot somebody who is trying to gain entry through a window. I'm saying that if you interpret this or if you understand this law, you have to understand that there will be an interpretation of whether or not that actually constituted unlawful entry.
Correct.
Probably it would be adjudicated in your favor, but there is room for it to not be adjudicated
Correct.
in your favor. The other thing that usually comes from that too is the question of, well, if I shot them and then they died outside, should I then drag them back in the house? Because we hear that recommendation from law enforcement more than anyone else. That is bad advice. Do not do that. Number one, it doesn't matter where they died. If they died in the hospital, you're not going to drive down to the hospital and bring them home and then say to the cop, "Oh, this is where he died." Uh, the question is not where they died. The question is under what circumstances did you use that level of force? So don't pay any attention to anybody who says, "Oh, make sure they die in the house." That is tarded. Uh, the other thing about this is there is room for you to lose these cases. So you are not 100% okay just because you think that this was 18.1.704.5 and you're immune from criminal prosecution. You can screw this up and you can open doors for a prosecution if you don't follow some good advice in the aftermath. So even though this is technically immunity defense, it is still not a slam dunk case, and you should be careful in the aftermath.
Yeah. Um, I'm going to put it up, whatever. Use of physical force in defense of property. A person is justified in using reasonable and appropriate physical force upon another person when and to the extent that he reasonably believes it is necessary to prevent what he reasonably believes to be an attempt by another person to commit theft, criminal mischief, criminal tampering involving property. But he may use deadly physical force under these circumstances only in defense of himself or another as described in 18.1.704. So again, to kind of highlight outside of your house can't defend property. So for those of you guys with little peepees, you got the little willy, and you're like, it's so tiny, it's like a super micro one that you feel like you need to defend. You need to defend property. Here's your law right here for those of you with super micro ones. Ta-da.
Real quick, going back to physical force, or defense against intruder. If your situation does not include all of these elements, dwelling, occupant, unlawful entry, reason to believe a crime is being committed or about to be committed, reason to fear for the safety of any of the, or reason to fear that that person is going to use physical force, no matter how slight. If you don't have all of that, then the case automatically becomes defense of a person. 181704, even though this took place inside of a dwelling. Common example, you're having a poker party and things go sideways and a fight breaks out. Everybody in that poker party would presume to be invited into the dwelling. Now, it gets a little bit more complicated than that, but this is why you will see cases where it took place in the home but was not considered home defense.
Correct. Yeah, absolutely. The same goes for anybody who you've ever had a personal relationship with, brothers, sisters, exes, that type of stuff. You would need a restraining order at that point to kind of establish that you need a protection from them. And the idea there being that if you just broke up with your ex and they want to come back to retrieve their stuff, you can't just shoot them, even though you guys agreed that that person no longer lives there. Well, one, did you go through the proper eviction process to get rid of them, or did they just leave? It could technically still be considered their dwelling because you would have to evict them. So it gets complicated there. So yeah, if you've ever had a personal relationship with the individual, not know who the person is, but have had a personal relationship with that individual. So yeah, that's good clarification there.
And in general, having a previous relationship with your attacker is likely to increase the complexity of your case. Yeah. So if you're dealing with a former roommate, an ex, a family member, even somebody that you just spent a lot of time with, a previous relationship does complicate self-defense claims. That's just a general rule.
Correct. Yeah, I don't think there's anything else. I think we covered most of it. I hope this video, unless you've got anything else.
No, I think that covers the things that we typically will cover in the class. Strongly encourage you, if you care about the laws in general, and to some degree Edgar and I do, in some degree we don't, but on this level we do care quite a bit. Right. And we do strongly encourage you guys to watch this video more than once. It takes time for this information to settle in. It takes time to understand it, and the more experience you have, the more you will be able to interpret the specific words and phrases.
Yeah, I appreciate you guys watching this. We'll probably did you want to give them a word or something that they have to whisper to us or say to us, not say it out loud in the classroom so everybody hears it? If you do this, we enter you into a monthly raffle. I'm not going to commit to any specific. Last time I did, I won't commit to anything specific. And by the way, for legal purposes, this now voids the other one from the other video. No longer valid. This is the one we did on 9/12/2023 with Isaac. This is the new raffle. I'm not going to commit to something, but we'll give you a prize, a gift card, maybe a free live fire class or what have you. Something we'll every month we'll do something different. You'll win something, sometimes $100, sometimes a coffee, whatever the case may be. But
yeah. So your entry into this non-raffle contest for legal purposes is you have to tell us who you think was better in this video.
Me, duh.
And you have to be specific about it. I'm telling you this. I'm telling you who I think is better in the video.
Yeah.
And then if you do that, you will be entered into our
But
monthly.
we don't want to see
giveaways.
this. We don't want to see everybody at Isaac's class saying, "Oh, you were better just because you're at Isaac's class."
No, no,
Correct.
you have to be honest. You
Correct.
have to be
Yeah, for
truthful.
sure. I just remember I'm Mexican. Isaac is white. So anything you say against me, racist. Uh, you are racist.
And anything you say against me, I will revoke your
Yeah.
privilege immediately.
So I appreciate you guys. Again, just to kind of recap, LexisNexis.com, that's the website right there. This entire time, I was Edgar Antillon, and then the other guy was Isaac Chase, Guns for Everyone. Super duper appreciate you guys watching this video. It's going to be here for some time. We're also going to keep it. I think I am going to post this and make it live for everyone. So share it with other human beings. Don't be shy with hitting the share button. Yeah, I got nothing else. Usually we're a little bit more organized, but we wanted to get this out there and get you some more relevant information. 9/12/2023. I will say there are other laws that you should pay attention to that passed this year in 2023. Has nothing to do with concealed carry. So we didn't talk about it. Many of them are stuck in lawsuits. Rocky Mountain Gun Owners, as of right now, has that information. So go watch that. Go to their website, Rocky Mountain Gun Owners. Just Google them. I think it's rmgo.org, and they'll explain which laws passed under their Bill Watch, that tab, and then it'll also reference the lawsuits that they have been so far victorious in. It's not a full win, but a lot of them have injunctions which are better than temporary restraining orders. So go to their website, rmgo.com, get information for the laws that passed in 2023. Again, it has nothing to do with concealed carry, but it does have to do with guns. One of them is long guns can no longer be purchased by 18-year-olds and now has to be 21-year-olds. Privately made firearms, that type of stuff, that change. Again, the 18 to 21, that one is in lawsuit right now. So it technically hasn't passed. 3-day waiting period, that's technically in the lawsuit right now. It doesn't go into effect until October 1st, but it's probably going to be in the lawsuit, so it probably will not go into effect. So again, many laws that pass has nothing to do with your concealed handgun permit. But still, if you're interested in freedom and all that stuff, Rocky Mountain Gun Owners, as of 9/12/2023, is the place to go. I say that because in 5 years, they may not like us, we may not like them, or things changed, the laws did pass, or they got completely revoked, what have you. So as of 9/12/2023, go to Rocky Mountain Gun Owners and look up that information. Stuff from you.
No, thanks for making it this far in the video. Tell your friends, and we look forward to seeing you guys in the class.
Yeah, buddy. See you guys. I'm gonna cuss a lot.
Thanks.
A lot.